I'm Dan Phila. I am the Dean of the Drexel University Kline School of Law. For those of you who saw me once already this morning, that's a repeat. And I'm really excited to welcome you to this panel. Our panel starts out today with Darlene Hemerka, who is a staff attorney at the Public Interest Law Center in Philadelphia. And I'll give relatively brief introductions. Ms. Hemerka joined the Public Interest Law Center here in Philadelphia in 2017. She focuses on representing parents in IEP meetings, advocating for teens with disabilities in the Philadelphia School District, and teaching students and their families about secondary transition services. Before she joined the Law Center, she was a judicial law clerk at the Superior Court of New Jersey, and she received her JD from the Penn State Dickinson School of Law. Next up will be Louis Bossing, who's a senior staff attorney with the Bazelon Center for Mental Health Law. He works on a broad array of issues affecting adults and children with mental disabilities, including community integration, special education, and criminal justice. And before he joined the Bazelon Center, he worked as a staff attorney in the Civil Rights Division at the Department of Justice. That was a different time. And at the Legal Aid Society Employment Law Center in San Francisco. He holds his JD from NYU School of Law. Next, Terry Jean Seligmann, who's Emerita Professor of Law, and indeed, here at Drexel's Kline School of Law, and indeed was a member of the inaugural faculty here at the school's founding, and she helped create our Boast Moment highly ranked legal research and writing program. And her scholarship has focused on issues of statutory and interpretation and judicial review of the IDEA, and she's published in the Journal of Law and Education and the UC Davis Journal of Juvenile Law and Policy. Her prior practice included representing the Massachusetts Department of Education during the implementation of Chapter 766, which is a state law model for the IDEA. And she is also the parent of a child who received special education services. And in that capacity, she was a member of her school district's Parents Advisory Council for Special Education. And finally, our last panelist, certainly last but not at all least, is Jasmine Harris. She's a professor of law at UC Davis School of Law. And she describes herself as a law and equality scholar with a focus on disability law. And in her work, she combines approaches in law and humanities to understand the role that perception, aesthetics, and emotion play in group subordination, using this as a way to argue for better anti-discrimination laws. And her work on disability rights appears in the NYU and Columbia Law Reviews and is forthcoming in the Penn Law Review. And it's really exciting to see, this is a moment of sort of stepping back as a person who's done disability work myself, to see her work in the area of disability law get those kinds of platforms, because those are not always where work in this area falls. So this is, sort of as an important side note, seeing disability law get that attention is, I think a really meaningful thing in and of itself. And so I'm really appreciative of her contributions. Before joining academia, she worked as a staff attorney herself at a national civil rights organization, the Advancement Project, where she assisted grassroots advocacy campaigns around racial justice in education and juvenile matters. So this is a great panel, both with current people who are really in the fight, and people who've been really engaged in the fight and have also sort of gone into the academic world to think about it. So I will open up, and we'll start with Darlene, and at the end of the 4 presentations, we'll take questions.
Thank you so much, Dean Phila. So good morning, everyone. Today I'm going to talk to you all about using class action lawsuits as a tool to protect the rights of students with autism. But before we get into the presentation, I just want to tell you a little bit more about the Public Interest Law Center. Our mission is here on the screen, but we use high-impact legal strategies to advance the civil, social, and economic rights of communities in the Philadelphia region, and particularly those that face discrimination, inequality, and poverty. We use litigation, community education, advocacy, and organizing to secure these rights, or to secure these services, excuse me. And we focus in 6 different areas, so healthcare, public education, environmental justice, housing, employment, and voting. And our public education work includes special education, which is what we'll talk about today. And we were founded in 1969 as part of the civil rights movement and the call of President Kennedy for lawyers to get involved in that movement. So our objectives for today, I'm going to provide some background on filing a due process complaint under the Individuals with Disabilities Education Act, or IDEA. And then we're going to talk a little bit more about when to consider if a class action lawsuit might be the appropriate litigation strategy. And finally, we're going to use a case called PV versus the School District of Philadelphia to talk about what makes for a successful class action under the IDEA. So just a really brief overview of the Individuals with Disabilities Education Act for those that might not have been here for the last presentation. The IDEA is the federal law that protects students with disabilities, or I'm sorry, provides the rights. Let me try that again. Provides students with disabilities the right to receive a free, appropriate public education, better known as FAPE, to meet their unique needs. And the main tool that school districts use to fulfill their obligations is the Individualized Education Program, or IEP. The IDEA requires that a school district provide meaningful parental participation and prior written notice whenever it initiates or proposes to change the educational placement of a child. However, neither the IDEA or the legislative history define educational placement. And so that was one of the main issues in the PV case that we're going to discuss a little bit later. But before we get to talking about class actions, it's really important to understand due process hearings and those procedures. So we're going to talk briefly about that. If a parent believes their child was denied FAPE, he or she can file a due process complaint with the Office of Dispute Resolution. And they must also send a copy of the complaint to the school district at the same time. And then under the IDEA, the school district must hold a resolution meeting within 15 days of receiving the complaint. And then if the complaint has not been resolved after 30 calendar days, then the due process timeline begins. And under the law, there must be a due process hearing and a decision issued within 45 calendar days of the due process timeline beginning. And that's under the Pennsylvania Code. So the entire timeline can take a maximum of 75 days unless the parties agree to extend the deadlines. And IDEA requires that parents exhaust these administrative remedies before filing a lawsuit in federal court. So now that we have a little bit of an understanding of how to bring due process complaints, there are some additional considerations that folks need to think about when deciding whether to bring a class action under the IDEA. One is the issue of exhaustion, which we just briefly touched on. Then there's also the issue of class certification under Federal Rule of Civil Procedure 23. And a third consideration is whether the issue that you're trying to remedy is a policy or practice, or if it's a specific program or service. And we're going to get into that a little bit more detail as we walk through the case. So the case that I want to talk about today is called PV versus the School District of Philadelphia, or SDP, as I'll probably refer to it. And as part of your materials, you should have gotten different motions or at different procedural postures within the case. So we're just going to go through some of the highlights of each of those different opinions from the court. If you could go back one slide really quick. Thank you. So it was a class action that the Law Center filed in 2011 on behalf of 4 parents of children with autism. And the main facts were that SDP did not have autistic support classrooms in every school. So the AS classrooms taught students in grade bands. So for example, students in grades kindergarten through 2nd would be in one classroom, and then students in grades 3 through 5 would be in another classroom, and grades 6 through 8 would also be in a classroom together. But the autistic support classrooms often did not span the entire school. So while students in regular education would stay in an elementary school for grades K through 5, students who received autistic support might only be able to stay there for K through 2 because the school did not offer an autistic support classroom for grades 3 through 5. And what happened was when students reached the end of the grade band, they would automatically be transferred without parental notice or involvement. These parents filed suit alleging that these transfers were a violation of the IDEA, and specifically they sought relief to discontinue the transfer policy, or if that wasn't possible, provide more information and opportunity for parents to be involved in the transfer decision. So when the student reached the end of the grade band, they wanted parents to have more information and more involvement in that decision. So once the complaint was filed, the school district filed a motion to dismiss, and they argued in part that the complaint should be dismissed because only 2 of the named plaintiffs exhausted their administrative remedies. But the court denied the motion to dismiss because they found that having students repeatedly file administrative complaints when the hearing officer actually found that he did not have the jurisdiction to provide the broad-based relief that they sought would be wasteful and ultimately prove fruitless, because hearing officers only have the authority to grant individual relief and cannot order systemic policy changes, such as discontinuing the transfer policy. And in this case, the hearing officer actually said that in his decision, that he could not grant the relief, but he did encourage the district to change their policy. So next, the plaintiffs filed a motion for class certification in February of 2013, and the school district raised several arguments against class certification, and one of them was that the named plaintiffs' claims were not representative of other class members, and their argument was that for some students, the best placement might be at a school that does not offer autistic support classrooms at all grade levels. But the court was unpersuaded by this argument because the plaintiffs requested relief included providing parental participation and involvement for parents, which the court found was in the interest of all parents. And finally, the parties filed cross motions for summary judgment, and the issue at the summary judgment stage was whether these transfers constituted a change in educational placement and thus required notice to parents. The parents argued that these transfers were a change in educational placement and thus required parental notice and involvement, but the school district argued there was no legal requirement to notify parents because educational placement only includes the educational program and programming and services, but not the actual location where the student receives the programming and services. And the school district relied on a case where a student with a specific learning disability was transferred by the district, but the court found that that was not a change in placement. But here, the court was able to distinguish that case from these current set of facts and found that a change in location did constitute a change in educational placement for students with autism, because an unplanned transition for children with autism is likely to affect their learning rate and learning sequences. And that's because difficulty with transition is one of the defining characteristics of autism. So when considering whether you should bring a class action under the IDEA or if that's a great strategy, look for cases that involve policies or lack thereof rather than specific programs or specific services. The case law is pretty clear that school districts get to decide what kinds of, like, let's say the parent wants a particular reading program, that the case law is very deferential to schools in determining which programs should be used. And so that's why it's best if you have a particular policy. You also want to exhaust administrative remedies for some, if not all, named plaintiffs. Again, in PV, the hearing officer specifically stated that he did not have the authority to provide the plaintiffs with the relief they were looking for. So in that case, it was okay not to exhaust for all the named plaintiffs, but some other cases have suggested that you have to exhaust for all the named plaintiffs. And then you also want to consider what characteristics might be present with that particular disability and whether the policy has a particularly negative effect on those individuals, like in PV, where because students with autism struggle with transition, those transitions were really particularly negative for them.
Thank you, Darlene. Appreciate those comments. And next up to Lewis.
Yeah, thank you, Dean Phila. It's a pleasure to be with you all today. My name is Lewis Bossing, and I'm an attorney at the Bazelon Center for Mental Health Law. I kind of have to tell people who may not know, the Bazelon Center has done a lot of things to try to advance the rights and protections for people with disabilities, both children and adults. I can tell you that back near the beginning of the Bazelon Center's 45-year history, when it was the Mental Health Law Project, the Bazelon Center was doing legal advocacy around the rights of children with disabilities just to be in the classroom, just to be in the schoolhouse, in litigation that was foundational, I think, for special education law going forward. That said, I have been at the Bazelon Center for 13 years as of yesterday, and I am constantly learning that I have a lot to learn about the special needs of autistic students and how schools can meet those needs. And so it is a learning process. I'm looking forward to learning today. And I'm really excited to be on the panel with Darlene and Professor Seligmann and Professor Harris to learn from them and to learn from everyone who's here with us today virtually. There's going to be a little bit of overlap among us. I wanted to talk about Bazelon's more recent work on public education for students with disabilities, which, as I was looking at it, does seem to involve a lot of autistic students and litigation and other efforts to try to advance their rights. The Bazelon has spent a lot of resources over the last 3 years trying to affect, after actually 4 years, trying to have an effect or try to influence the Supreme Court's decision in the Endrew F case, which is now 3.5 years old. And as you all may know, it may have already been discussed today, was a case in which a young man with an autism spectrum diagnosis in Colorado, I would say clearly wasn't getting the public education he needed. And his parents sued his public school district, the Douglas County School District in Colorado. And they took their case all the way up to the Supreme Court of the United States. And I think the justices on the court at that time actually understood that the state of special education in this country, as driven by rulings from its federal courts, was not good. It had not produced enough benefit for students with disabilities. And as a result, students with disabilities were not getting a free and appropriate public education as the law requires. And they were not enjoying the same kinds of opportunities for success in schools and then as adults as everybody else in our country does. And so I think in the Endrew F case, and I won't belabor it because I know Professor Seligmann is going to talk about it. I think the justices really did want to make an impact on how schools were serving students with disabilities and what schools were required to do in order to provide a free and public education for students with disabilities. And if you could flip back just to the prior slide. Thanks, Evan. Thanks very much. You know, I know Professor Seligmann will kind of address this in more detail, but you know, by the time the Endrew decision was, by the time of the Supreme Court's proceedings in Endrew and the decision in 2017, I think the courts had generally landed on some articulation of a standard by which, as long as students were receiving some benefit from education, and some courts went further, as did the court overseeing the decision in Colorado, and said that as long as a student was only getting a merely more than de minimis educational benefit, that was enough. That was enough under the IDEA, our special education law. And as long as the student was getting some benefit, they had no dispute. They had no issue. I think the Supreme Court actually thought that was not the way it should be. And so they issued a decision which sent Endrew's case back to the lower courts and indicated that the standard for what a school had to do was to provide a special education that was reasonably calculated to permit the student to make progress unique to the student's circumstances, paraphrasing just a little bit. And I think that the court intended that would actually raise the bar for what schools were required to do under the IDEA. The Bazelon Center, you know, spent time trying to influence the court through the filing of amicus briefs in the court. And since the Endrew decision, has spent a lot of time trying to influence the lower federal appeals courts about, you know, how Endrew should be interpreted, how it should be applied. I think you have in your materials for the symposium some of those amicus briefs involving autistic students. And I think I would just be remiss, and I know Professor Seligmann might say this as well, and I would be remiss without pointing out that in the Supreme Court's Endrew F decision, the Supreme Court said that it was a markedly more demanding standard for what schools must do to provide a free and appropriate public education to students with disabilities, and that students should have the opportunity to have an appropriately ambitious education with challenging objectives. I think despite all of us as advocates, our best efforts, sometimes the courts are losing sight of, the lower courts are losing sight of this language from the Endrew decision, which really was intended, I think, to raise the bar for what schools must do. Next slide, please. Another thing that I think the lower courts may not have noticed, or don't seem to have noticed as much as I would like, as much as many of us would like, is that the Supreme Court noted that for most children with disabilities, special education is going to take place in what they call the regular or the general education classroom, which is where students with disabilities can receive instruction, in academics and instruction in areas of social emotional learning, along with students without disabilities. For most students, and I think from the Bazelon Center's perspective, for virtually all students with disabilities can be served in general education settings. If the school sets up systems in which the instruction in academics and in social emotional kind of learning can take place. In fact, I would say that, FAPE, free and appropriate public education, that meets the standard that the court intended in Endrew, is most likely to happen in the general education classroom, where students with disabilities are learning with other students without disabilities, and where both from our work in the field, but also supported by data on outcomes, it's where students generally are more likely to get standards-based academic curriculum and the kinds of expectations around behavior and supports for behavior that are likely to kind of give students the opportunities that they need to be successful. Next slide. I think I would, it is not just that I think the law requires a focus on inclusion in the general education classroom as the default setting. And it is only where that, a free and appropriate public education cannot be achieved in a general education classroom that you would look to other settings, within the school or in separate schools or at home. But the data shows that when you do include students with disabilities in general education settings, they do better than students who are in segregated settings, even where, as this slide indicates, where you're controlling for the presence of cognitive disabilities. Students in general education settings are closer to grade level and have, higher academic test scores. The markers that may be imperfect, but that we use to try to understand whether our systems are working to give all students equal opportunities. Students do better in general ed than they do in segregated settings. And next slide. That's not just about those markers of grade level or academic achievement scores. Those indicators of social emotional growth, such as kind of being able to participate in extracurricular activities or in community, activities, school attendance, discipline, those proxies where we look to see whether or not students are getting the kinds of supports that they need. Students who are included in general education do better on these metrics than students who are segregated. Next slide. And that success, in school means better outcomes as adults when you're looking at employment, when you're looking at participation in post-secondary education, when you're looking at income. I was grateful for the opportunity to provide slides today, and I have some sites on these slides. I hope everybody gets a chance to take the slides home, and you can take a look at this data later. But these are well-known studies that are now decades old that show that, students who are included in general education are likely to do better in school and later in life. Next slide. And I again have to point out that there is a racial equity component to this question around inclusion. You know, given that we have known for decades about all these benefits, and given that our laws have required that general education be the default, it's unfortunate that students of color and low-income students with disabilities are generally less likely to be included in general education classes when compared to other students. And you know, there's a really horrible history of using segregated settings for students with disabilities as a means, I think, of affecting racial or ethnic segregation in our schools. And of course, that is something that we're still dealing with today. Next slide. As I said, the Bazelon Center not only tried to orchestrate amicus briefing in the Supreme Court in Endrew, but we also co-authored a brief on behalf of former officials of the United States Department of Education who are responsible for special education. And because, you know, we wanted the court to know how the high standard we wanted the court to announce could be reached, we talked about the really large body of research that kind of supports, you know, the approaches that schools can take in order to be able to provide free and appropriate public education to students that would meet kind of the high expectations we should have for students with disabilities. And so our experts from the Department of Education, the former officials, talked about multi-tiered systems of support. I'm sure for many of you here, this is not going to be surprising. Multi-tiered systems of support for both academics and for behavior that would, you know, promote kind of general standards-based curriculum or general curriculum around social emotional learning, or a general expectations for behavior that all students should be expected to meet, and then identifying those students who may need additional supports. Sometimes, you know, could be provided for some students in small group instruction or in other kinds of kind of medium range kind of interventions. And then for a top tier of 5 to 10% of students, kind of overlapping with students who may qualify for special education and have individualized education plans, program plans, you know, higher tier of supports. And schools that have kind of been able to implement not just the kind of universal tier of supports, but also look at those second and third tiers are having, you know, again, great, you know, improved outcomes for students of the kind that I've been talking about. Another thing that our Endrew brief talked about was universal design for learning, and how, you know, every student is unique. School classrooms should really, you know, teachers should be able to provide for different ways of relaying information, providing different means for students to demonstrate mastery of material, different approaches to engaging students. Often can be achieved in classrooms through differentiated instruction that would kind of allow students to work at their own rate and to demonstrate knowledge, their knowledge in different ways. Project-based kind of interventions and instruction in the classroom. These are all ways in which our experts have indicated that schools can include students more effectively in general education settings. Next slide. And then because Andrew F has been an autistic student, was an autistic student at the time that he began his journey through public education, our brief in Endrew looked at, you know, specifically at supports for autistic students when support is needed, understanding that sometimes autistic students may behave in ways that are different for some others in the classroom, but that should be, you know, accommodated because that is who they are. And you don't need to do a lot of planning or support when a student is behaving in a way that is not kind of interrupting the education of others. That's just who that person is. And schools, I find that schools need to do more to understand that and make that a part of how they support a student. When support is needed, as our Endrew brief indicated, there are lots of ways in which autistic students can be supported through, for instance, figuring out when behavior is an effort to communicate, and then providing functional communication training for the student that would help that student communicate in different ways, pre-teaching, prompting, just giving a student a chance to regroup when there has been a lot of activity in the classroom. Certainly when needed, a functional behavior assessment or behavior intervention plan where there may be, a need to kind of investigate more thoroughly what it is that may be causing a student's behavior, what consequences the student may be attempting to gain from the behavior, and then figuring out creative ways to help to support that student's behavior through a plan. The Bazelon Center, like Darlene and her work, is interested in using systemic legal advocacy to try to improve systems for supporting students with disabilities, and really to try to ensure that schools and states, and even at the federal level, are, doing what Endrew said they have to do, which is to ensure that students, receive appropriately ambitious instruction and have the chance to meet challenging objectives. I have listed and I provided some complaints from a couple of our cases, one against the Oregon Department of Education, where hundreds of students with disabilities have been subjected to shortened school days, which is one tactic that schools use, which is just to shorten a student's day when they don't really know how to support a student full-time in school. This case was brought on behalf of 4 individual students and the Council of Parent Attorneys and Advocates. 3 of those individual named plaintiffs are autistic students. And so we're trying to get the Oregon Department of Education to do a better job of enforcing the Endrew standard for its students, to make sure that they all receive a free and appropriate public education. Next slide, please. And then there is another case that we filed this year with partners in West Virginia, GT versus the Board of Education of Knox County. That's on behalf of a putative class of hundreds of students with disabilities who need behavior supports. And I would say, because they haven't gotten effective ones, have spent a lot of time being suspended from school or experiencing other disciplinary removals from school. 2 of our individual named plaintiffs, one of whom has an autism diagnosis, the other has Down syndrome diagnosis and autism. There we are, trying to use litigation to get this school district to implement systems so that these 2 students and other students like them get the supports they need. I just wanted to, in the last slide I have, look at the future briefly. I think I included in the packet for the symposium the Leadership Conference for Civil and Human Rights position statement on school climate. I think we're going to see, we have these laws that protect students with disabilities, and including from the overuse of discipline to kind of as a method of behavior control. I think we're going to see new efforts in the next Congress to try to come up with additional legislation. And I can tell you that advocates for students with disabilities are going to be at the table. Students of color with disabilities specifically are more likely to be disciplined. They're more likely to experience restraint and seclusion. They're more likely to face corporal punishment. The list goes on. And so I think it's important that any new legislation that addresses the overuse of discipline and these other methods of behavior control, and that tries to foster improved school climate, taken into account students with disabilities, including students of color with disabilities. And so I can assure you that advocates are working to make sure that that happens. I gave you my contact information, and I'll look forward to the discussion after Professors Seligmann and Harris presentations.
Thank you, Louis. We'll move next to Terry Seligmann. But
Good morning, everybody, and thank you, Dean Phila. So I don't think I need to tell people about the foundations anymore because we've had so many speakers cover them. The only thing I want to highlight is that we really only had 2 major Supreme Court cases on what was required under the IDEA to meet the FAPE obligation. And the first one was in 1982 in the Rowley case, which was widely viewed as not appropriately ambitious, to use that phrase. And then Endrew, which Mr. Attorney Bossing has talked about, which Louis has talked about. But I am going to try to focus a little bit on a piece of these 2 cases that hasn't been talked about yet, which has to do with the choice of methods, or what's sometimes called methodology. So the Rowley decision, as Louis outlined, talked in very minimal terms. But another thing that it did, because, sorry, let me go back here. Rowley, some of you probably know, involved a student who was hearing impaired, whose parents wanted to have American Sign Language used in the classroom. They wanted an ASL interpreter. And the school district took the position that the child was in 1st grade and was a great lip reader and was doing just fine and did not require ASL. Back in 1982, this was probably much more controversial than it is today as to which methods best benefit hearing impaired children. But the court, in upholding the school district, essentially said that courts could not impose their view of preferable methods on the states. And that if a plan was designed to provide FAPE, then the way it would be, the educational methods were a matter for the state's expertise, essentially. And that sort of leads me to this whole question of autism and why it is we see problems under IDEA with kids with autistic characteristics. Students with autism who are at the end of the spectrum where they have greater needs often have needs for early interventions that are very intensive. One of the most popular approaches is called applied behavioral analysis, which is essentially one-on-one interaction with a trained person and a lot of cueing involving visual cues. I'm not an expert in this. I'm not going to try to be an expert, but you can imagine that that takes a lot of staff and time, ABA. And a lot of parents believe, and there's some studies to suggest it, that it's one of the more effective ways of helping autistic children make a transition to allow them to be in social settings and respond to cues and join a general education classroom. It's also the case that there is often some significant behavioral issues that have to be addressed. And so there's a lot of special ed needs here. And the statistics show us that autism disputes are a fairly significant proportion of all the litigation that's brought under IDEA. I put a source at the end of the slides that you'll have with Perry Zirkle, who does a lot of big data crunching of various kinds that looks at that. I think there are several reasons why that's the case. One is that, as Dean Phila pointed out, disability cuts across the spectrum of class and race. And when children of people with resources and higher socioeconomic status have children with disabilities, the IDEA actually provides a lot of power to those parents. But it also requires resources, as Professor Stein said. So the more needy and resourced the parents are, the more ability they have to use IDEA and to bring disputes to resolution. So I think that's one reason. Another reason is that when expensive interventions are called for, school districts may be more resistant to providing them. So they become money cases. Money cases as in expense for the school district, as an expense for private school tuition if parents have taken the step of moving their children. And so we get those sort of tip of the iceberg cases involving litigation that have a fairly high proportion of autism disputes in them. After Rowley, I tried to take a look at how this methodology language was affecting autism disputes. And I think you all have a copy of an article from back in 2005 that suggested that despite this language about methodology being for the states, in the lower federal courts at least, depending on how the case was being made at the level of the hearing officer, and then in the reviewing court, courts were not necessarily blindly accepting the school district's view about the best methods, which I thought was encouraging. Endrew, I think, in addition to talking about the need for a much higher standard, also talks about the methodology issue in its language. And so I just want to focus on that. This language here, I found very encouraging in the opinion. While deference to school authorities as to educational policy is due, deference is based on the application of expertise and exercise of judgment by school authorities. And again, saying to reviewing courts, really, by the time a case gets to court, it's up to the school authorities here, not completely the burden of the parents, but the school authorities need to show that they actually have a reason for their positions. And I put this language here because I do think it's important in disputes where the school district takes the position that they are providing a perfectly fine program for an autistic child based on their expertise, and the parents are taking the view that what's being offered really doesn't reflect what autistic children need, that this gives some encouragement in that fight, if I can put it that way. So, as I said here, a lot of the court disputes end up being cast in a way by school districts as methodology disputes. But I think that what parents and advocates have at their disposal is casting them as FAPE disputes and using expertise, which was mentioned in the criminal justice panel, and it made me think really of how important it turns out to be in these disputes. Making sure that that expertise is there. Again, we have this resource issue for parents because expert fees are not reimbursed under the IDEA. But experts make a big difference when these cases are in dispute. And not only which experts. I've been reading some of the cases since Endrew F, which Lewis and his center collect regularly. And some of them are a little discouraging, but I find that they're turning on things like how much expertise did this expert really have for the parents? You're up against teachers, as Professor Stein said, who teachers and school districts who have their repeating ability to produce evidence and expertise. And if the parents have only their ABA therapist who doesn't have a college degree, they are, even though they think that's the person who knows their child best and that person may have the most opportunity to observe, that may not be enough to sway a case dispute. So this sounds a little practice oriented, but as Dean Phila said, we're always talking about bringing theory into practice. So credibility of your expert, credentials, and then attacking observation on both ends of it. Who's had the most opportunity to observe this child? How little was the child observed by the school district who has their classroom ready for the child? Then the other area that Lewis touched on a little bit is behavior. And I don't think that schools are as quick to understand when they need to do a real assessment of behavior as they should be. And this is also an area where disputes result in orders for children. And then the last big area, I think, and a really big one, an important one, is how is the child evaluated? What assessments are being used? And for parents to actually use the ability to get an independent evaluation at the school district's expense if they feel the evaluation is not adequate. The discussion about funneling and post-transition pipeline and the effects on African-American kids made me think about this as well, because as Lewis said, there's a lot of evidence that when it comes to discipline, African-American kids are being disciplined at much higher rates and pushed out of regular classrooms at much higher rates. And some of those children needed evaluations for potentially ASD and other disabilities and never got them. So evaluation is critical here too. And I would think at the higher ends of the ASD spectrum that that's the kind of thing that slips under the radar a lot. Okay, and then I just want to, also mention, I think you did, Lewis, that there's a lot the IDEA requires, and if it can be used by the people it affects, it can be very impactful for children. Transition services, occupational therapy, speech and language therapy. And then I just thought, we're in the middle of a pandemic, and I ran into a slideshow by Gary Meyerson, who, if you know any special ed, you know his name because he is a private attorney who's been very, very active. So I thought I would just mention that IDEA has not been suspended by the existence of our pandemic, and it becomes perhaps really important that records be kept of what's being delivered and what's not, and that compensatory education is in fact an available remedy under the IDEA, and also that there's a 2-year statute of limitations, so you can't wait forever to raise complaints. So just from a practical perspective, I know right now there are a lot of issues around the delivery of special education, but these are things to think about if you are representing parents and children with autism. So I'm not going to go through these cases. I put them on the slides. I know the slides have been distributed. They're just a sampling of cases. I was trying to think if I could draw any big conclusions out of them. And I think that there's, if I could say there's hope, I think what I see in them is that the hearing officers who hear these cases at the administrative level have developed a lot of expertise over the years in understanding educational evaluations, testing, needs, IEPs. I think the judges need to recognize that a little more than they are, judging from the cases I'm seeing. I was not happy to see some of these cases just reversing hearing officer decisions and saying this boils down to a methodology dispute, because I think in most cases it doesn't. And I think that's a distortion of the Endrew language and even of Rowley.
Thank you, Terry.
Yeah.
And we're going to go next to Jasmine.
Great, thank you. Thank you, Dean Phila, and thank you to the Drexel Law Review for this invitation, and to my panelists, my fellow panelists, for your thoughtful comments and your research and your advocacy. It's invaluable in this area. And so what I'd like to do today is I would like, given the time, to jump as fast as we can into the Q&A. But I do want to touch on some things that I believe have not been talked about and to add to the conversation. And that's really I'm going to do three things rather quickly. The first is to discuss some conventional views in the media and in the research about autism and race in special education. The second thing I'd like to do is offer some thoughts on how we might think about this issue, the issue of race and the intersectionality that Lewis brought up. And so I think offering a few thoughts will generate hopefully some conversation in the Q&A. And then the third thing is to offer, as we do, some practical, concrete ideas for how we might move forward with respect to intersectionality and race. And so very quickly, as I began to prepare and think about what I would say for this panel, I thought about the Mills versus Board of Education case. And that's a case from 1972. It's often seen as the other side of the Park versus Commonwealth of Pennsylvania case from the same year, where it basically was discussing the rights, the constitutional rights, in the sense of the parameters of kids with disabilities. The Park versus Commonwealth, of course, was kids with developmental and intellectual disabilities, and the Mills versus Board of Education case was primarily kids with behavioral disabilities or psychosocial disabilities. And the reason I thought about Mills is because when Mills gets described, Mills often omits, or people omit, one important factor, that all 7 of the named plaintiffs were African Americans. And so that component of race, I think when I teach special education law, that's what I put up front right away. Why? Because it's a nice contrast. Well, not nice at all, but in our business, we say terrible things are nice. So it's a contrast to the Park case, very much so, with respect to who the litigants are in terms of the racial component, and thinking about the diagnosis. So the students of color were very much in the bucket of behavioral disabilities, emotional disturbance, that they were exhibiting non-normative behavior, and the students, the white students were put in the box of intellectual disability, developmental disability, learning disabilities. So it was a very interesting, I think, contrast. So I start with that because the Mills case offers that racial lens. And then secondly, another notable point about Mills was that basically the District of Columbia School District said, look, we don't have money. And so we don't have the resources to serve these kids. And so we exclude them from school. And the court said, you can't do that. You have to use the resources you have equitably. And so my response always there in thinking about this is, okay, how do you distribute 0 equally? 0, right? I mean, it's a poorly funded school district to begin with, so they're really behind the 8 ball. So it goes back to Professor Stein's keynote remarks and remarks that my fellow panelists have made about the importance of being resourced in this process, not only in terms of parents, but in terms of school districts and what they can do. Okay, so very quickly, let me just talk about the conventional thinking. So there are a couple of thoughts that are out there. The first is that there's an overrepresentation of Black and brown children in special education. And that's a big piece of it. The second is that there's an underrepresentation of Black and brown kids in special education. How can both be true? Well, if you disaggregate, and folks have said this today, if you disaggregate by category, you'll see that the autism category in particular is increasingly being populated. It's growing in terms of the number of students who are having access to special education through that category. And if you look at the racial and demographic profile, it's mostly middle-class white students. So when we talk about that, I think we need to talk about it in terms of race, but bias is not the only answer. So there's been some research by sociologists to really change the frame of how we discuss this and to really focus on cultural capital, what sociologists call cultural capital. That is, you know, the networking, it is the resources, but it's also the networking between parents themselves that leads to destigmatization and can really advance the conversation about, oh, you really ought to get your kid evaluated. Here are some of your rights. The, you know, next door platform where you can talk to your neighbors and say, gosh, my kid has been having this problem in school and what can I do? The access to those resources is quite important. Okay, so thinking about the change in frame, I'd say, we should, of course, think about racial bias. It's there, but I think we also need to broaden the conversation to really focus not only on class and parent individually being able to dole out money to pay for evaluations, but the resource networks that come into play. And so I want to leave time for questions, so I will offer just a couple of practical prescriptions. I had a little bit more to offer, but I do want to hear people's questions. And so some practical prescriptions. The first is, let's stop calling IEP teams, because they're not. That's what Professor Stein was saying at the beginning. They're not teams, right? It's 9 people in a room and they have an agenda and you come in and they've already met for an hour talking about your child, and you know, then they take a vote on whether this is the offer of FAPE or whether this is the right diagnosis. Let's change that. And in order to change that, I think we need to really think seriously about a civil Gideon in the special education context. And so the question is always, how do we find the money to support representation for parents? And I think it can be done in a number of ways. Right now, legal clinics are serving an invaluable role here in representing low-income parents and parents of color. And so that's okay, but that's just a Band-Aid. So we need to come up with a funding stream, either directly from the states or the federal government, for a civil Gideon to deal with that imbalance. Why? Because the record is established in the IEP meeting. Those imbalanced meetings themselves are creating the record. Who can go to those 2-hour half-day meetings? Parents who have flexible jobs. And so you see the inequities in terms of you know, who gets to do the administrative work, what Professor Liz Emmons calls life admin, the sort of, you know, filling out the forms, staying online with the insurance company, you know, all of that stuff takes time and is not compensated. And so that's what I think sociologists are getting at when they're talking about cultural capital, parent to parent, but also, you know, across both horizontal and vertical lines. And so I think it enriches how we think about the racial inequities in special education, particularly when we talk about autism, which is being overconsumed in terms of the services, and it's a race to consume those services by parents who are well-resourced. So I am going to stop here. I know I use my New York speed voice here, but I definitely would like to hear from others, and I'll take questions and get more deeply into this if you'd like. Thank you.
Thank you. Kelly, you are up.
Hi, everyone. Thanks so much for joining us. I had a question. So what are the minimum requirements for an individualized education program under IDEA? And do you believe these minimum requirements are sufficient?
I'm happy to take the first swing. The minimum requirements, and there are probably too many for me to get into, but as a general matter, first, if a parent is concerned that their child isn't getting appropriate supports, they may seek eligibility for special education. And if the child is determined to be eligible, and Professor Harris said this so well, the school should convene a quote unquote IEP team. Ideally, of course, that process should function as a team. Too often it does not. But the law you could argue that the law envisions a process by which, and indeed, in other contexts, teaming contexts, you'd want to put the child and family at the center of the team and ensure that their input and parents, particularly as the experts on their children, kind of are provided every opportunity to provide input as to what they think would be helpful interventions, both in terms of academic supports and behavioral supports. And then that goes into a written plan, which I think people might describe as a contract, or at least has some legal significance. And then the school would be charged with implementing that plan. And that plan should be revised at least annually, if not more, depending on the child's needs. I'll let my other fellow panelists do a better job than I did, but that would be my version of the basics.
I just wanted to add one thing. Thank you, Louis. That was pretty comprehensive. But I think I'm going to add to it the child fine obligation. And so school districts have an affirmative duty to locate and evaluate students with suspected disabilities or existing disabilities and test them for eligibility for special education. And so I think that's in theory, a really powerful provision that doesn't get a lot of play in terms of the legal significance. And so, when we think about how do school districts find individuals, it's, really through the system, once you get through the school system, are kids falling behind? And so one of the problems with our special ed system is that you have to fail in order to receive support. And so there needs to be a record of failure. And so we need to address that piece as well. But in terms of minimum requirements, in theory, the school district should actually carry out their affirmative obligations in line with what Louis said.
Whitney, do you want to go ahead and ask your question?
Sure, thank you. So I was wondering, how much does a school district funding have an impact on IEPs? Is it more often a case of a school district not wanting to provide proper IEPs, or of a school district being financially unable to provide proper IEPs, or something else?
I'll start just by giving the legal answer. The legal answer is that FAPE is required regardless of the cost. And there is Supreme Court law on that. There's federal money that is, funneled through the states to school districts for what's in theory help in meeting the extra costs of educating kids with disabilities. It's never been enough. But from the perspective of the individual student, it should not be because of cost. But we all know that those are constraints.
And just to add to that, not only is it not enough, but the federal government has never fully funded its obligation under the Individuals with Disabilities Education Act. And so that's a big part of the deficit in terms of funding.
I'm going to jump in with a question if that feels comfortable. I am curious about how much of this is, if we were to get a burst of funding, how much of the issue that we're talking about here today is fundamentally going to be about receipt of more funds, or how much is the culture of what I'll call FAPE denial so baked in that resources wouldn't immediately change things, because these teams and the staff in them, you know, have a momentum to them. I mean, one of the challenges from when I was doing special ed work in the 90s and early 2000s was how many teachers had not themselves been trained with the perspective to be positive, sort of FAPE positive. And so I guess my question is, looking at all the different things you do as practitioners and theorists, does it take something more than money to burst this?
I think you raise a really good point. I agree with all the other panelists that, you know, the federal government has not fulfilled their obligation, and resources would help. But I also think there is certainly a lack of training for teachers around different strategies to use, particularly for general education teachers, because as was talked about in some of the presentations, the best outcomes come for students that spend more time in general education classrooms, but you know, I don't think our general ed teachers get enough training about how to provide those supports in a general ed classroom. So I think it's funding, but I also do think it is a change in, it's more training, but it's also a change in attitude within, you know, where students should be receiving these services, and how do we get them the most supports in the right settings.
I agree with Darlene 100%. I think we have to face up to the normative challenge, which is, it's broader than just teachers understanding disability, it's society. And so that's a big piece of whether we can really say ASD along a continuum, or folks are just narrowly focused on or see individuals with ASD as the most severe cases. The most severe cases obviously continue to need that support, but I think it's that differentiation that we're missing. And I just want to plug a paper that I have coming out in Penn Law Review about this idea of the way in which privacy prevents us from understanding and differentiating disability. And the idea being, you know, privacy has been used almost as a sword to make people feel like they have to hide who they are and not identify publicly as an individual with a disability. And so the privacy laws do that work, because we've envisioned that they should. Our anti-discrimination scheme uses them quite heavily. So I think we need to rethink the way we see privacy to really change social norms. So that's all I'll say.
I would just add, I agree with that. I would add that it is unfortunate that a system has been developed in which you have to identify as a person with a disability, as a student with a disability, to get supports and services that you may need. I think it would actually be, and if we're talking about, you know, changes, systemic changes that would support everyone, is if we had a system that provides the right to all students to get whatever kinds of individualized supports and services they need in order to be successful. That you wouldn't have to identify as a person with a disability, which has been so stigmatizing in our society, in order to be able to get whatever individualized supports and services you may need. I've certainly been to schools along the way where they've kind of instituted an approach where every child basically has a plan, a learning plan, and that plan would identify whatever individualized supports they may need. And so I personally, because I think that special education is a separate system, and so therefore kind of prompts segregation in a way that denies people who are segregated equal opportunities, I wish we had a system where we didn't have to have that distinction made in order to get the support you need. And so I'll leave it at that.
Hi, yes. So when applying the standards in the Individuals with Disabilities Education Act, several district courts have been accused of applying an outdated and misapplied standard that sets the bar inappropriately low. Was this problem widespread, and do you believe that the Supreme Court should have created a more rigid test for applying the IDEA? And would a more rigid test even work?
I'll start, and then Lewis can tell me what all the stuff that I've missed. I think there after the initial case where people were disappointed with what the court did in Rowley, that there are a lot of people who felt that what was actually happening in the lower courts was that standard was being beefed and used with a lot more teeth than perhaps the Supreme Court had intended. Mark Weber, who's a professor at DePaul and writes a lot in special ed, wrote an article about the re-radicalization of the IDEA and put forth that idea that whatever the Supreme Court was saying when these cases came up through review into the district courts, they were demanding better results for kids than that language might suggest. Now there are going to be people who disagree with that, and certainly Judge Gorsuch, whose opinion it was that led to Endrew, got it wrong. He's the one who wrote more than merely de minimis into his opinion in the 10th Circuit. But the Third Circuit, for example, had adopted a meaningful benefit test way before Endrew. So from a purely legal perspective, it's a hard thing to assess, and these cases are so individual that it's hard to generalize. And I'll pass it on. That's enough for me. So.
Yeah, I'll just say, you may know that the plaintiffs in Endrew in the Supreme Court actually argued for a higher standard, substantially equal opportunity. That a free and appropriate public education would mean that a child would have a substantially equal opportunity as students without disabilities to achieve. And, I think the Supreme Court took the tack that because every individual is unique, it would have been hard to say what substantially equal opportunity means for every student with a disability, and that since Congress had not written that standard into the law, it wasn't going to write that standard into the law. So it came up with different words for a different standard that I think they hoped would mean a higher standard that was closer to something that was equal. As someone who does, and I don't know what Darlene would say, as someone who does systemic legal advocacy in which we are, trying to measure whether students with disabilities have equal opportunities, which is, I would say, the requirement under the Americans with Disabilities Act, which applies in schools, and Section 504 of the Rehabilitation Act. We would look at whether or not they're having the opportunities, the same kinds of opportunities for extracurriculars, for electives, and we'd look at outcomes. We'd look at, I think, in order to measure, you would have to look at whether or not, the outcomes in whatever outcome metric we agree is appropriate. But in other contexts, we look at academic test scores, and we see whether or not the academic achievement of students with disabilities is reaching the same level as that for other students. And at Bazelon, we've certainly argued that for most, for virtually all students, there should be, ways in which those academic achievement metrics should be measured and found to be promoting equal opportunities. Should be kind of that there's no reason not to for students with disabilities to be able to make the same achievements, and that we should have the same kinds of expectations that they do. So I think that's to be continued in a way where we're continuing to push how the Americans with Disabilities Act works in public education, and also trying to lift the standard in Endrew.
I'm going to have to take that phrase, to be continued, from Lewis, because our time we've run over a bit. And I feel sad because I'm not sure KL Renard maybe has a great question up, but that question is so big that we couldn't answer it. And I'm sure these are the questions that everyone on this panel ponders, like capturing the last sentence. How can we address the lack of oversight and consequences for FAPE denial, noncompliance systematically or on a national basis? Huge question, really important. You know, what the Public Interest Law Center and what Bazelon, like, that is core to their, questions. So reach out to those folks if you want to have more engagement, because we all want, that's what we want, and the answers are not immediately visible. Thanks to all of you. I so appreciate your participation and engagement today. This whole event brings together the mix of people who are interested in the sort of scholarly questions and the practical difficulties for their kids, for the system. And I appreciate all of you engaging this today, but I also want to really say, and this is a personal thing, I want to really express appreciation for all that all of you have done and do on this issue, because at the Kline School of Law, we're thrilled to put on a panel today, but this panel is a couple of hours. The work that each of you do, and it's divergent, whether it's walking into a courtroom for one person, for a collective, or writing articles that shape conversations and help reshape them. I think that is the answer to that last question we addressed. So every day that you do that work's good work, it's important work. We only change the world one piece at a time. All of you are doing it. Thank you so much for your participation today. And everyone, please come back at 1 o'clock for our next event.